Hello and welcome. I'm Peter Afrasiabi. I'm a partner at One LLP. We are intellectual property and entertainment lawyers with offices in Newport Beach, California and Los Angeles. And we focus really on copyright, trademark, patent, entertainment disputes, and many times defamation and defamation-related torts. And so today's program is Deppamation, which is a way for us to look at the defamation tort through the Johnny Depp trial, the Johnny Depp Amber Heard trial that was highly publicized in 2022 and in an earlier case in England raising similar issues in the last couple of years. But it raises a great vehicle really to sit down and take a break, take a time out from your practice, pick up some continuing education and look at an overview of defamation and the defamation tort, what it is, how it works, some of the limits. And along the way today, there will be a lot of practice pointers as we work through what we as lawyers really need to be doing and thinking about when we advise clients to march into defamation litigation so that we protect ourselves from the potential lifting of the Pandora's box that can happen when one opens themselves up to truth as a defense. So let's get rolling and let's start by looking at some of the Johnny Depp Amber Heard trial evidence. And you see here, and we'll hear some videos along the way of certain clips, but you see here some of the exhibits that were introduced in the trial involving Johnny Depp suing Amber Heard for defamation, whereby he had made certain claims that he was being defamed by Amber Heard, who issued an op-ed piece in the newspaper talking about fundamentally being a survivor of spousal abuse, implying that Johnny Depp had abused her. And so this is the big defamation case that was in the US courts in 2022. And here's some of the evidence. And this sort of gets very quickly to the point I really started on, which is when we file for defamation as a plaintiff, we need to make sure our clients understand that discovery is broad and the kimono, so to speak, will be opened and much stuff will come out that may or may not help the case. Maybe it doesn't matter to the case, but maybe it matters to your broader network of people you know, your community, publicity. If you're a mega celebrity, then the whole world knows. You're airing your dirty laundry in public, in other words. And that's one of the fundamental things that can happen. And one of the fundamental things that we as lawyers need to be, and we are very careful on the plaintiff's side for defamation plaintiffs, to advise them about the potential scope of what can come out. So let's take a look at some of the stuff that came out, because ultimately what we're asking here is defamation. Is it worth it? Do you want to go down the defamation road? Yes, no. It's a very complicated calculus that's more than just a legal calculus, but we as lawyers have to be advising people carefully and cautiously on whether they want to go down the road based on what can come out. So look here. Here's an exchange between Johnny Depp and one of his friends, Mr. Bettany, where they are talking about, and I don't know the context. One could imagine it being not serious, non-serious, laughing, joking, whatever it may have been, but it's pretty brutal stuff. Talking about, here's Johnny Depp, drowning Amber Heard before we burn her. I will fuck her burnt corpse afterwards to make sure she's dead. And then his friend Bettany says, my thoughts entirely. Let's be certain before we pronounce her a witch. So is it some drug-induced crazed conversation? Is it serious? Is it not? Who knows? But it's nasty and ugly, and it's certainly embarrassing, one would think, to have the world know that you talked about fucking her burnt corpse of your former spouse. And this is sort of this is an example of the stuff that comes out that we need to be advising clients. Before you pull the trigger, let's know what's out there. And as long as you're okay with it, so be it. We're off to the races, but let's protect ourselves as lawyers, right? Here's another one where some exchange between Amber Heard and someone making reference allegedly to Johnny Depp, saying he was appalled when I told him he kicked you, he cried. There's some other statement saying, showing pictures of like destroyed rooms, and there were videos of rooms being destroyed and damaged and sort of just the melee of the relationship, all of which now has been publicized. And some sort of a message here saying, once again, I find myself in a place of shame and regret. Of course, I'm sorry. I really don't know why or what happened, but I will never do it again. I want to get better for you, and for me, I must. My illness somehow crept up and grabbed me. I can't do it again. I can't live like that again, and I know you can't either. I must get better, and I will for us both starting today. I love you again. I am so sorry. I love you and feel so bad for letting you down. So these types of things, this is just sort of a little snippet of some of the more salacious things probably, but that gets us to our overview. So that's sort of the foundation of where we're going to go today as we really start exploring the upside, the downside of do you want to do it or not. So we're going to look today at defamation as a tort, the overview of it. We're going to look at the defenses. We'll also walk through the public figure and constitutional limits that exist because of New York Times versus Sullivan, which we'll talk about, in terms of standards for suing public figures for defamation, or public figures being able to sue for defamation, that is. We'll look at damages models and some of the Daubert challenges that can come up here on causation correlation, which become particularly important when you're really dealing with defamation cases, where you're saying that someone said X to me, and after X, all these things happened to me, and they were caused by X, right? That, is it causation? Is it a correlation? It comes up all the time in all economic litigation, but particularly in defamation litigation, where one is trying to somehow contextualize the harm that has befallen them by someone else's negative statement. And so the tendency is to look at data, event, new data. Is there causation? Is there correlation? These are the things we're going to look at within the law because they're very important here. We're going to look also at social media platforms and liability for user speech, because there are obviously big immunities on the internet for social providers in terms of how they are protected for online defamation between you and me defaming each other online. We're doing it through Facebook. Facebook has standards that protects it. We're going to look at the open questions before the U.S. Supreme Court. And we're going to look briefly at some of the anti-SLAPP statutes. These are strategic litigation against public participation statutes in various states, including California. And of course, along the way, we're going to have client advice and practice pointers so that we can really be protected as lawyers ourselves and make sure that there's no boomerang events for us. So let's start really quickly, at least with a factual overview of the Johnny Depp Amber Heard trial, facts at least, sort of just the big picture issues of what was going on. So Amber Heard writes an op-ed piece with 3 statements, and apparently it was ghostwritten or co-authored. It's unclear to me exactly, but the ACLU was heavily involved in it in one way or another. And it had 3 statements in it, and she eventually then retweeted the op-ed piece that was published. And there were 3 statements that the jury ultimately found defamatory. Her statement that, "I spoke up against sexual violence and faced our culture's wrath. That has to change." That was the title of her op-ed piece. "2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out." That the jury found was defamatory too. And then her third point is, "I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." That too, the jury ultimately found defamatory in the lawsuit by Johnny Depp. Now, Amber Heard counterclaimed in the case because Johnny Depp and his lawyers had made various statements, and the jury found at least one of the statements by one of Johnny Depp's lawyers defamatory. And here's the statement. "Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight on the direction of a lawyer and publicist, and then placed a second call to 911. So that claim that they had sort of manufactured an environment as a hoax to make it look like she was abused or beaten, the hoax claim about her claim of abuse, the jury found at least that aspect of her counterclaim legitimate. And then the way it shook out is the jury gave Johnny Depp, net around $10 million. There was some more that the court took away under Virginia state law for punitive damages, and $2 million to Amber Heard on her counterclaim. So those are sort of the big picture facts of how it shook out. And obviously, many of us heard about it, saw bits and pieces of the trial. It was certainly filling conventional press for a long time, a remarkably long time, actually. As a little aside, it's almost astounding that they were given 4, 5, 6 weeks, however long it was for trial. I mean, as those of you who practice in the state and federal courts know, it is very rare to get that much time for a case. I don't know if because they were celebrities that they were given more time, but I can tell you it is almost unheard of for us in our cases, even far more complicated, obviously, copyright, patent, trademark disputes to get 6 to 8 weeks. Never happens. But nonetheless, Let's start. Practice pointer, first one. And this comes out of really the counterclaim. Before issuing any press or public statements on behalf of your client, go get consent in writing from the client and get a written agreement that the client understands that that statement, if it's to be issued by you as a lawyer, it may trigger defamation liability, and that liability is not going to be borne by you. It's got to be borne by the client. You need some sort of a waiver. You may even want to get independent counsel to approve it, but you want some sort of protection for yourself if you, as you saw, Johnny Depp's lawyer made those statements about the hoax. That was defamatory. You don't want to find yourself in a position of fighting for the cause of your client, issuing a public statement, and that statement being held to be defamatory, at which point you got a problem with your carrier and your client potentially. Another way to look at it is simply don't issue any public statements and don't approve of any public statements. The latter is a subset, right? The clients, sometimes they're fighting in the public domain and they want to issue statements to advance their cause, and that's many times the case for much litigation, and that's obviously acceptable within our context of press and First Amendment. But you as a lawyer want to make sure you protect yourself heavily in terms of any statement that you approve for public dissemination. You better make sure that it's not defamatory, that it's absolutely defensible within defamation law, and frankly, you probably want to get client waivers and client indemnity, vis-a-vis you in case you ever get dragged into it. So you want to look to protect yourself heavily before you inject yourself into the public domain in that way. And I think that's an important way that lawyers can, on the front end, protect themselves and be careful and not find themselves in jeopardy. So let's start now by diving into defamation and doing an overview of the tort. Fundamentally, defamation revolves around and seeks to redress injury to reputation. The injury can occur by means of libel or slander. Libel is the written form of defamation. Slander is oral. It's a false and unprivileged oral communication attributing to a person specific misdeeds or certain unfavorable characteristics or qualities, or uttering certain other derogatory statements regarding a person. And that ultimately is what constitutes slander or, if written, libel, both of which are under the rubric of defamation. So here's the general rules. To establish defamation, the plaintiff must show that a false statement of fact was made, that the statement was defamatory, that the statement was published, and that the plaintiff suffered injury as a proximate result of the publication. Now, there's an additional state of mind element depending upon the subject matter of the victim, and this is sort of what gets to the public figure, private figure issue. If it's a private figure, I'm a private figure, you're a private figure, you say something negative about me, I want to sue you for defamation. The standard is negligence, and there's no obligation for me to show malice in terms of your uttering of the words. If, on the other hand, it's a public figure, I'm a famous celebrity talking about some issue that I'm a celebrity on, and there's a defamation case, and my content is the subject matter of public discourse, or I'm in that space and I say that you defame me, I now have to show malice in terms of the uttering when I bring my defamation case, because I'm a public figure and I've injected myself into the public domain on certain things, and that means I have shed certain rights to the full embrace of the defamation tort. These basic rules that I just gave you, this is just a California Supreme Court case from 1989, and it's basically the same in all jurisdictions with minor variations here and there, but that's the gist and the general overview, and that's Brown versus Kelly Broadcasting at 48 Cal 3rd 711. Let's look now at this public-private figure issue, because it's an issue that's fascinating from the U.S. Supreme Court. It interjects itself and inserts itself into defamation tort law. It's happened over a half century ago, and it's now percolating around again in the courts as maybe going back to the Supreme Court, 70-odd years later. So let's look at the case. This is New York Times versus Sullivan. And everyone's probably heard of Sullivan, but many times people aren't aware of the underlying factual background of what Sullivan was really about. So it's good to sort of unpackage the case a bit. In 1960, the New York Times published a full-page ad by supporters of Martin Luther King Jr. that criticized the police in Montgomery, Alabama for their mistreatment of civil rights protesters. And the ad had inaccuracies regarding facts such as the number of times King had been arrested during the protests, what songs they were singing, and whether students were expelled for participating. And so the Montgomery Police Commissioner sued for defamation. And the trial court found that because of the factual errors in the ad, that it was defamatory per se, and the jury awarded $500,000 against the New York Times. The Alabama Supreme Court affirmed. This then goes up to the U.S. Supreme Court. And the U.S. Supreme Court held that the state cannot allow damages against public figures for defamation absent actual malice, specifically that the statement was made with knowledge of its falsity or with reckless disregard as to whether it was true or false. And that was a 9-0 decision. And so this has been extended over time to all public figures, not just public employees or officials, such as Sullivan was as the police commissioner, but celebrities. I mean, people who are in the public space, who interject themselves into a public space for even a limited purpose. And what's important about the case then, as we sort of think about this public figure issue that came out, is the animating force, and we'll look at some clips in a little while, but one of the animating forces that sat beneath this decision was the fact that it was a civil rights case ultimately, that you had the South resisting desegregation, using defamation law in state courts as a means to punish dissemination of information about what was going on in order to narrow and chill the ability of sort of information to get out about what was happening in those states. And so it's in that context that this public figure issue was raised by the Supreme Court with a malice standard, which made it then much harder for officials in the South resisting desegregation to take on the press in their accounts of what was happening. And that's the context that gave birth to the actual malice public-private figure test set of issues. So on the next slide, this comes from Gallagher versus Connell, and this is a pretty standard statement of the law across jurisdictions too. It's 123 Calap 4th, 1260, 2004 was the case. And here we're looking at the rationale for what public figures are and what exactly they are. And so public figures really come in two forms. You have the all-purpose public figure, someone who's achieved such pervasive fame or notoriety as to become a public figure for all purposes and in all contexts. And then a limited purpose public figure, someone who injects themselves or is drawn by others into a particular public controversy and thereby becomes a public figure as to their role in that controversy. And so this can also be involuntary groups of people too, and that would be as identified by one's assumption of roles of special prominence in the affairs of society. And so what's the rationale for the different treatment? It's this: public figures usually enjoy significantly greater access to the channels of effective communication, and hence they have a more realistic opportunity to counteract false statements than private individuals normally do. And they assume such roles of power, or they thrust themselves into the public discourse on issues. So in other words, if you have massive access to the press, you're George Clooney or President Obama or something, and you have the ability to court the press, to communicate, to have your voice heard and disseminated in a way that regular people don't. But that also means if you're unhappy about something said about you, you don't just get to sue. You have to be able to show malice for the statements that were uttered by you by the New York Times or by People magazine or whatever it is, because the theory being you have means of redress to combat unliked speech. Hence, you need to show something more than just someone made a mistake in terms of what they said about you. This brings us to our next practice pointer. Truth is a defense. And this raises the issue of what's important for us as lawyers to counsel clients on, of the Pandora's box implications to lifting that lid in a defamation case. And so let's watch some clips here on YouTube as we circle back to our trial. Here you go.
In this text, Mr. Depp, you text Mr. Bettany, "Let's burn Amber," 3 exclamation points, right? You see that?
I do see that.
And at this time, June 11, 2013, Amber is your girlfriend or perhaps even your fiance at this point, correct?
Girlfriend.
And you wrote that about the woman who would later become your wife.
Yes, I did. It was a photograph of the bed, our bed, and on my side of the bed was human fecal matter. So I understood why it wasn't a good time to go down there. My initial response to that was, I laughed. It was so outside. It was so bizarre and so grotesque that I could only laugh.
And the night before you were due to meet up, did you have a heated discussion on the telephone with Miss Heard about what was happening with James Franco, the scene she was doing with James Franco? Answer, I do not recall, but it is highly likely. Did I read that right?
You did.
And you suspected that Amber was having an affair with James Franco, correct? That was the reason for your argument.
Yeah, yes.
What happened? Nothing happened this morning, you know that?
Were you in here?
No.
So then nothing happened to you this morning?
Yeah, you're right. I just woke up and you were so sweet and nice. We were not even fighting this morning. All I did was say sorry.
Did something happen to you this morning? I don't think so. You want to see crazy? I'll give you crazy. That's crazy. Oh, you're crazy. Oh, you're crazy.
Have you drunk this whole thing this morning?
Oh, you got this going? You got this going?
I just started it.
Oh, really?
Yes.
Really?
All right, so everything can come out. This is one of the issues. There's incredibly broad and wide scope of relevance. There's elasticity in these things. It's very hard to tell a plaintiff on the front end, don't worry, those bad things about you will never come out. They'll be 100% shielded. It's so hard to say that given the elastic nature of relevancy and the breadth of relevancy in the law and when truth is a defense. So this is a sort of fundamental practice pointer on the next slide, and that is on the plaintiff's side, before engaging in defamation suits, really make sure there's a very clear letter to the client pre-suit that makes clear the massive scope of intrusion that will happen in the discovery process. There's a potentially, maybe infinitely elastic scope of relevancy depending upon a judge's rulings. And for any plaintiff you represent, to protect yourself on a claim later, coming back from your client, that they didn't know the scope of what would unfold in terms of the intrusion into their private affairs and their frustrations at the brutal process of discovery that kind of lifts the kimono on everything. Make sure you have a clear letter that's making clear that's what they're buying so that you don't get blamed for it. And that's just the reality of what they're purchasing. That's the reality of the litigation that will unfold. And you do not want to be in a position of making guarantees as to anything being off limits, given the fact that judicial rulings can be so broad and lawyers can be so creative at how they make relevant all manner of things that you may think are irrelevant. Let's take a look now at some of the damages models that sit on the back end of defamation. And this is, again, premised on the fact that if you think and peel the onion back on what the defamation tort is, we're talking about general damages for reputation and for personal injury. This forces us to start asking, when we want to somehow crystallize those damages, and you're talking about damage to reputation, you need a means of showing that as a result of the injurious statement, the defamatory statement, something befell you, and there's going to be an economist and a curve and a delta between these two curves, and you want to ascribe that delta to the utterance of the defamatory statement. And so that's what we're going to start looking at a little bit. Overview quickly. Some states have retraction requirements pre-suit in order to get reputational type damages. So you want to be very, very clear if you're in a state that requires that, because you need to give the opportunity to the defendant to retract. And you have to ultimately show proximate cause by the false utterance. And so that's very important, because proximate cause is what starts getting to these questions about causation. Is it a causation? Is it a correlation? Is it a statistically significant correlation? What is it? And defamation per se allows presumed reputational damage and then exemplary damages even, absent proof of reputational injury or other special damages proof. You can also get special economic damages for lost income and the like, and then in some states, punitive damages too. Let's now look at some of the damages models and some of the limits given the fundamental principles of Dauber and in similar state Supreme Court rulings you'll have in your jurisdiction that track kind of the idea of Dauber in terms of reliable scientific evidence. And start here, the basic fact. Shark bites and ice cream sales are correlated. I mean, really they are, believe me. It sounds crazy, but it's true. The question though is, does one cause the other? I mean, the fact that in the same time of year that shark bites go up, ice cream sales go up, shark bites go down, ice cream sales go down, they almost perfectly line up the curves. It's incredible. The question though is, so what? I mean, is there really a relationship between those two independent variables, between ice cream sales and shark bites? I mean, does eating ice cream make you go in the ocean and get bitten by a shark? Do sharks like people who've eaten ice cream, right? I mean, it's nonsensical, obviously. So the idea that you have these two independent variables that are very tightly correlated, the idea that you would draw a causal inference between them and say that one caused the other is nonsensical. And this is the danger of correlation, the importance of causation, and it's particularly prevalent in defamation cases, where you have something that's been happening to a company, for example, has been making, or Johnny Depp, he's been making a certain amount of money. Amber Heard says something negative, he's making less money. He wants to say it's a correlation, more than that, it's a causation. I'm now making less money because of her statement. And the question is, always when you're looking at a correlation between two independent variables, the amount of money you're making, the statement made, you have to figure out if there's actual proximate cause and causation. And just seeing a relationship is not enough. And correlations, just bare correlations, generally don't even survive any kind of rigorous Dauber challenge and shouldn't even be allowed before juries most of the time. And so this is why experts become particularly important in defamation cases where you have independent variables that we as lawyers look at and go, oh wow, there must be a relationship. But judges and juries need to know, is there really a relationship? And that's why we need experts to rein us in and tighten us in. And that's also why on the front end, if you go back to another practice pointer, a client comes in and says, I've been running a business, I've been running it for all these years, I make a certain amount of money, my competitor said all this bad stuff about me, now I'm making less money, oh my gosh, I'm owed all that money. You don't want to rush in as a contingency lawyer, for example, and assume that all that money is going to be something you can monetize. And you want to tell the client, even if they're paying you hourly, we don't know if that's a relationship. I mean, is it because you have newfound competition that you're actually selling less? Is it because the economy's gone into a recession that you're selling less? What else is happening? What are the confounding factors out there? And so assuming causation fundamentally is very, very dangerous, and this is particularly true in the defamation context. And so you have to ultimately have an expert that can look at the two factors and figure out if that correlation between those variables is actually statistically significant, and indeed if they can opine on causation, actual causation. And so here are a few cases that just kind of high-level points that courts have made about this to rein you in on your analysis that you should be aware of. Huss v. Gaydon from the Fifth Circuit, 2009. Any scientist or statistician must acknowledge, however, that correlation is not causation. I mean, that says it about as simply as you can. U.S. versus Valencia, this is the Fifth Circuit also. Evidence of mere correlation, even a strong correlation, is often spurious and misleading when masqueraded as causal evidence because it does not adequately account for other contributory variables. McLean versus Metabolife out of the 11th Circuit. There you're dealing with toxic tort claims and questions of evidence of correlation or temporal proximity cannot establish the required causative nexus between a defendant's act and of a plaintiff's ensuing injury. And so that's often another way the correlation gets discussed is temporal proximity. And so you want to say that upon the heels of this happened. That temporal proximity is your causation. Who knows? But don't assume it. And that's one of the huge mistakes that's made often in litigation is on the front end, it's assumed the correlation is causation. It's never adequately tested with experts often. And then you'll be on the receiving end perhaps of a defense, powerful defense motion in limine or Daubert challenge to any of your evidence, and you'll end up being non-suited for lack of causation evidence. And so those limits are really, really important. Here's an example, and they rear their heads with different names, but here's another example in the terms of damages models and some limits given our Daubert issues. And this involves speculative damages, and this is DMF Trucking versus Colmac Energy. This is a California case from 2015. And there was a termination notice between these contracting parties, and the termination notice stated defamatory reasons, it was alleged. The plaintiff then sued and claimed lost economic damages, which were shown to be $400,000 was the actual cost of covering with new delivery drivers after the contract termination. But the jury also awarded $1.35 million in reputation harm damages. And what the Court of Appeal held is that the evidence supported the $400,000 numbers in terms of as a result of the defamatory termination of the contract, you had to go hire these people to cover. That cost $400,000. Direct causal nexus, yes. But the $1.35 million, the Court of Appeal said is that it's just this claim of lost business, that I would have had more business but for that statement. My sales went down. They would have been higher. The court there used the rubric of that's just speculation and just made up. And that's another way of saying it's a bogus correlation. It's a temporal proximity claim between two variables that doesn't make for causation. And so you will see it rear its head in different names, but you need to be aware of it. Now, in the Johnny Depp Amber Heard trial, let's take a look at some of the trial damages claims here to sort of talk about them, and then we can hypothesize them through these prisms. Johnny Depp claimed that the publication derailed his career, and he showed his pre-publication earnings and post-publication earnings. And so he said there was a correlation between those variables, and with experts, presumably a causation. Amber Heard did the same in reciprocal on her claims. She said that she was an ascending star, and she showed a decline tied to the time period after Depp's lawyer's statements. And so what she wanted to say is that my variable was I was in my ascendancy of my career, now I'm not, and so that chart I should have gone up versus where I am, that delta under that curve was taken from me. Correlation, causation, that was her problem too. Now, the one fundamental question here is how much of this is really worthy of causation at all? And this is what's really important in the causation analysis. You have to, through expert testimony, identify and assess other confounding factors. And it's unclear, to me at least, how much of this was done. I don't have the trial transcripts to read, and I didn't watch the 6-week trial day in, day out. But from trying to find the evidence online, it's actually not clear what exactly the expert reports had said. And so this really opens the door to other questions. And here's another issue that then becomes very important for us as practitioners. A defamation case, because of the causation standard and this idea of what really caused it, it opens the door, yet again, to other reams of potentially relevant evidence. For example, in the Johnny Depp case, in order to figure out whether his decline in earnings as tied to the variable of her defamatory publication, and he's then on an earnings decline, in order to figure out whether that decline was caused by that, as a matter of law, experts have to assess for other confounding factors. And well, what does that mean? In a defamation case like this, saying that, you beat me up or something, and, and the defense is, no, I didn't. Well, what else could have caused a decline in his earnings? In order to look at that, then you open the door to, okay, well, what was going on in your life? Were you a drug user? Were you having mental health problems? What else was going on, right? I mean, it's incredibly broad. And so this is why I said on the front end, the most important practice pointer is to educate your clients that it is infinitely elastic. And it's not just on truth as a defense, it's also on causation, because that you necessarily have to show confounding factors. You get to litigate confounding factors, and you open the door as a plaintiff to have people figure out what are the other confounding factors that may explain why your business has gone down. Who knows what's going on? all manner of theories can be put forward, right, by the defense to figure out confounding factors to explain other reasons for a decline in a company's profits or a person's earnings. Everything under the sun could explain that. So the fundamental tip here is don't just rely on a pre-event and a post-event change. Assume that there's a correlation. Assume that it's going to be easy to run into litigation. Just get a damages guy to say, oh yeah, there's a causation. Not that simple. Temporal proximity is a place where many people's cases have died on the rocks like a ship crashing, a pirate ship. All right, so the next practice pointer that is sort of a recap of what we just said, of course, is this need for clear written advice. And this is where I think on the front end of your case, if not in the actual retainer agreement, in some other concurrent letter, you want very, very clear advice on the plaintiff's side on the real scope of discovery of what's going to happen to your client and the real cost of experts to unpackage this stuff too. And on, for a defendant, it's equally true, and that is that, these same types of questions of non-economic damages and risks are pretty broad. And so you want to make sure your client knows that it's just not that necessarily easy to cut something off at the pass and win, that the tort itself allows for a broad range of different damages. And I think for both, it comes back to the idea of being very, very thorough with experts and being very conscious of that on the front end so you can do early discovery and really figure out the causation stuff early. Let's pivot right now to defamation tort principles in the online social media world. And so this, of course, brings us to sort of the federal immunity statute, Section 230 of the Telecommunications Decency Act, that has given online service providers broad immunity. And if we go back to understand where that came from, it came from really federal case law that dealt with federal immunity in the early internet years. And here we have a case of Stratton Oakmont versus Prodigy, where plaintiffs sued Prodigy for the defamatory comments that one user had made about another user through the Prodigy network on the Prodigy bulletin boards. And Prodigy was held to strict liability standards normally applied to original publishers of defamatory statements, and rejecting Prodigy's claims that it should be held only to the lower knowledge standard. And the court ultimately reasoned that Prodigy acted more like an original publisher than a mere distributor, both because it advertised its practice of controlling content and its services, and because it actively screened and edited messages. And so that was one of the big decisions that ultimately led to Congress enacting 230 to undo that reasoning, to say, hold on, service providers providing a platform, even if they're engaged in some content moderation to screen out certain things, don't become publishers. And that was sort of the rationale for 230 being enacted. So let's look at 230 here. And this is at 47 U.S.C. 230, the Communications Decency Act of 1996. And this is the fundamental language of 230 immunity when we're talking about online defamation. Which, by the way, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This, of course, by the way, is why Johnny Depp sued Amber Heard and not the actual online publishing newspaper, because the standards would be so much higher and harder given not just immunity for the online publication that the platform had presented, but also given the nature of other First Amendment issues that we deal with in defamation torts when we're talking about the press, and then the malice requirement. So that's why often you also see these cases then being battled out between individuals with results coming out differently versus whether one's suing an individual or a news outlet. But in any event, back to 230 immunity in the social media world, the question then is, what are online service providers? And they're really what are known as interactive computer services, and they're basically software providers, platforms, systems, the service, the system that gives access to people around the world who are getting on the internet to have a means or a mechanism or a platform to communicate and share information. Those are what's known as the online service providers, the information content providers who get immunity. So on our next slide, you see the twin goals, and that is that Congress wanted to encourage the unfettered and unregulated development of free speech on the internet and to encourage e-commerce activities online. And Congress also sought to encourage interactive computer services and users to self-police the internet for obscenity and other offensive material. So at root, it's this idea that they wanted to fertilize this new technology of the internet and let it grow and develop and flourish so that we would have this sort of new world of online free speech and online commerce, and a place where rather than have government rush in and regulate, could sort of self-regulate and patrol itself within the parameters of the law. Zoran versus AOL is one of the first cases then to interpret Section 230 dealing with all this sort of defamation online now. And this is coming out of the Fourth Circuit. And there we had the facts as follows. It was a case involving a false advertisement placed on an AOL bulletin board. And this directed users to call plaintiff, and which resulted in him facing endless amounts of harassment. And AOL was sued by Mr. Zoran, and ultimately the court held that AOL had full immunity. And here's what it said. Congress recognized the threat that tort-based lawsuits pose to freedom of speech in the new and burgeoning internet medium. The imposition of tort liability on service providers for the communications of others represented for Congress simply another form of intrusive government regulation of speech. Congress made a policy choice not to deter harmful online speech through the separate route of imposing tort liability on companies that serve as intermediaries for other parties' potentially injurious messages. And so that's the basic touchstone principle for social media online immunity. And so here, let's look on the next slide, and we can see different categories of cases. So you can understand if you're looking at bringing a defamation case and it involves an online service provider, where you're going to run into them having immunity and where they're not going to have immunity for the defamation. And so let's look at a few cases on the left side here where courts have held that Section 230 immunity applies. One is a negligence claim failed against MySpace, and you may or may not remember MySpace, but it was sort of the precursor to Facebook. And it was a negligence claim that failed against MySpace for failing to implement safety measures that would prevent minors from lying about their age. And so the basic argument was that you should do more to disable or disenable minors to get online. And nope, 230 immunity for that, and that's a Fifth Circuit case. Another one is the defendant, who ran an online discussion group around women's health, posted some third-party content that attacked the plaintiffs, who were two doctors critical of alternative medicine. And those unhappy doctors sued, and immunity was held because the defendant entity didn't create the content. It was other people just running around talking online, and so there was no claim there, and that's a California case. Finally, you have Dart versus Craigslist, and this is where Sheriff Dart sues Craigslist, arguing that the site's adult services section facilitated prostitution and created a public nuisance. And 230 immunity was granted to Craigslist there in terms of Dart's action, claiming that, you know, the adult section that allowed adults to meet and connect and have sex was a public nuisance or somehow unlawful, and that was not Craigslist's responsibility because it had 230 immunity as a service provider. Now we can see a few cases that fall on the other side of the line where there's been no Section 230 immunity. The first one is Anthony, coming out of the Northern District of California in 2006. Here we have a user of Yahoo's online dating services sued after he discovered that Yahoo made false profiles and sent users now defunct profiles to entice them to resubscribe. And there it was held there's no 230 immunity. And in large part that was because Yahoo was actually engaged then, not just reproducing other people's content or providing a platform for it, but actually making false profiles and sending them out itself. So that's its own volitional business conduct, in other words. Another case against Yahoo is Barnes versus Yahoo. This comes out of the Ninth Circuit in 2009. And here, Yahoo failed to take down a false profile of the plaintiff even after an employee assured her that it would be removed. And the court held that there was no immunity as to the promissory estoppel claim that was then brought against Yahoo. And so that's an example of how the original posting may not have been actionable as defamation, but when the complaint was made that you have false material online, you need to take it down, and the company said, yes, we promise you we will, and then they didn't, then they're sued for a promissory estoppel on a promissory estoppel theory. And then when they assert immunity, the court said, no, at that point, you entered a bargain with someone specifically to do something, you didn't do it. That's, again, your own business conduct. Finally, we have the situation of Mindspring hosting a website that infringed Gucci's trademark. It was notified multiple times that the site was infringing, but it never took any action. And the court held that Section 230 does not expand or limit existing IP laws, and so there was no Section 230 immunity. This brings us to Yelp, and we're going to look at the California Supreme Court and some very angry lawyers. And so the issue is as follows. Your client, or perhaps you, the lawyer, are angered by a defamatory Yelp post from a Yelp user. And what do you do to get it down? Yelp is an online service provider. Well, you sue, of course, and this is what the lawyers did in the case of Hassel versus Bird that made its way up to the California Supreme Court. And here are the really fascinating facts in terms of how the case was structured. Client named Bird hires the lawyer Hassel in a personal injury case. The client eventually became unhappy. And then suddenly Yelp postings appear, apparently from that unhappy client. And it said, steer clear of this law firm and research around to find a law firm with a proven track record of success, a good work ethic, competence, and long-term client satisfaction. There are many in the Bay Area, and with some diligent, smart interviewing, you can find a competent attorney, but this won't be one of them. So what happened is a lawsuit then is filed for defamation against the client in San Francisco Superior Court. Client defaults. A default judgment then is secured. And in the default judgment, the lawyers got an order that non-party Yelp had to remove the defamatory post. In other words, defendant was sued. The default judgment necessarily then resulted in a conclusion that the statement was defamatory and there was a need to take down the statement. But because it was a default judgment, the defendant, an order to the defendant to take that statement off Yelp was non-functional or non-viable. And so the judgment was then, taken to Yelp, or it was actually put in the judgment that defendant and any companies it worked with like Yelp would need to remove it. Well, Yelp gets that order and says, I don't think so. And so this is how the case then resulted ultimately in the California Supreme Court. Once the immunity applies, providers are immune from any claim arising out of content originating from a third party, regardless of the theory underlying the cause of action. And so lawyers or plaintiffs can't use creative backdoor litigation strategies to really get around what Section 230 would prohibit directly. Yelp could have promptly sought and received Section 230 immunity had plaintiffs originally named it as a defendant. And that immunity would have shielded Yelp from the injunctive relief that plaintiffs seek. So by enjoining Yelp to act, Yelp is inherently being treated as the publisher of the challenged reviews, and it is not engaged in conduct that would take it outside Section 230's purview in connection with the removal order. And so judgment as to Yelp was vacated. So it goes to show creative mechanisms to try to get around the breadth of the immunity won't work. If the online publisher can't be sued to take down material directly, then you can't get some backdoor order to do it. Got to get the user to take it down, in other words. Again, another example of how when you're running into defamation litigation, especially in the business context, and people are frustrated by postings on online sites, you want to be careful what you promise because it may be hard to get. Let's boomerang back now to the U.S. Supreme Court and defamation First Amendment standards. And we're, of course, talking about the Sullivan case that we talked about earlier. And remember, again, just as a brief recap, the holding was that the state cannot allow damages against public figures for defamation absent actual malice. Specifically, that the statement was made with knowledge of its falsity or with reckless disregard of whether it was true or false. Now, as we look on the next slide, we can talk about kind of what's going on in the 21st century and the 2020s. And some recent statements of Justices Thomas and Gorsuch are dissenting from a denial of cert in a case are as follows. Since 1964, however, our nation's media landscape has shifted in ways few could have foreseen. Back then, building printing presses and amassing newspaper distribution networks demanded significant investment and expertise. And thanks to revolution in technology, today virtually anyone in this country can publish virtually anything for immediate consumption virtually anywhere in the world. It's hard not to wonder what these changes mean for the law. In 1964, the court may have seen the actual malice standard as necessary, quote, to ensure that dissenting or critical voices are not crowded out of public debate, end quote. But if that justification had force in a world with comparatively few platforms for speech, it's less obvious what force it has in a world in which everyone carries a soapbox in their hands. So this shows, and this really gets to the issue of modern technology and that standard of malice for public figures and whether it's still a viable standard in this day and age. And we see two Supreme Court justices who are clearly raising questions about the ongoing viability of Sullivan. And so let's look on the next slide here at a couple clips, and we're going to look at each side of the debate, each side of the coin, so to speak, in terms of the competing visions of Sullivan's ongoing viability in this advanced internet age of the 21st century. And so the first clip we're going to look at is sort of, for lack of a better phraseology, what I call the First Amendment expansive theory or the civil rights angle. And this is just understanding the context of the Sullivan, New York Times versus Sullivan case in terms of how this broad expanse was really built and litigated through a civil rights angle, which is what gave birth to this requirement of actual malice that broadened the protection for speech that could otherwise be defamatory and injurious and narrowed the nature of the tort. The second one we will look at comes from a Federalist Society program, and it's a 2-minute clip from the Federalist Society talking about the viability and ongoing propriety of a doctrine like Sullivan within our constitutional framework. So let's take a look at the first one first. Here you go.
It's kind of interesting because we remember New York Times versus Sullivan as this great First Amendment precedent, and we remember all the cases that we wrote about in the book that came after it that expanded the scope of the First Amendment theories that were expounded in the book and revolutionized, as you said, libel law. But really, from the court's perspective, at least initially, New York Times versus Sullivan was a civil rights case, and it was about the fact that in the South at the time, there was this orchestrated effort to use libel laws by public officials to use libel laws to scare away the northern press so that the northern press wouldn't report about what was going on in the South. And it was no accident that 5 separate public officials in Montgomery and elsewhere in Alabama sued over this one advertisement that didn't mention any of them by name. The court very much viewed it that way. The day the case was argued, Reverend King was in the audience, and just so you think that the court was objective, Justice Brennan wrote in the term history that Justice Goldberg had a copy of Dr. King's most recent book and had it handed down to him to sign for him. It's very clear from reading Justice Brennan's term history and the other papers that we consulted in connection with the case and with the ones that followed it that there was no question they were going to reverse. The only question was how, and that's where Justice Brennan came in. That's where Chief Justice Warren turned to him, as he did so often in important and difficult cases, and said, okay, we have a result, now you tell us how we're going to get there and come up with the reasoning. Steve, on Monday, we were at another event, and I hate to steal your thunder, but he said it was like Chief Justice Warren gave Brennan the football and said, run it as far down the field as you possibly can. And that's what he tried to do, knowing the personalities of the other justices who were on the court and what he could basically accomplish. He pushed it as far as he could and accomplished as much as he could in that case and the others.
And now let's take a look at the Federalist Society program, which is the counter to that First Amendment expansive theory. Here you go.
To make it much, much harder for libel plaintiffs to recover than they used to. Now, maybe part of that is, people don't duel very much anymore. And as a result, we don't need to reward them. We don't need to lure them away from dueling with easy libel suits. But at any rate, we're now in a situation where the ability of people whose reputations are damaged to recover damages is much, much less than it was pre-Sullivan. And there is, if you read the court's cases on this, and also some of the correspondence within the court that Anthony Lewis mentions in his book, there's a class angle to this. Now, I wrote a book a couple of years ago called The Judiciary's Class War, in which I suggested that an awful lot of stuff the Supreme Court's done is driven by its sort of educated gentry class sympathies with other members of the educated gentry class. And there's a real feeling of class solidarity between the judges on the court and sort of the chattering classes that comes out in a lot of these things. It winds up being a subsidy to the press because to some degree, we like the press. They're people like us. And that feel comes through the opinions, especially once you start thinking about it a little bit. And I think the backlash has sort of come along, not least because the press gets a lot of things wrong, and people have noticed. And so that's what sort of brought us to the place where we are now. And it's not helping them if they've been laying off fact checkers and copy editors and such all this time. But we're now in a situation where I think the press doesn't have the deep well of trust and affection that it actually did enjoy among a lot of people, say at the time of Watergate and afterward. And I think that it's a bad time for the press for us to be having this discussion.
Well, there you have the debate, and the question is what side of the debate you come down on, and whether you think that the actual malice standard, which acts as a bar to access the defamation tort when it comes to public figures or limited purpose public figures, whether you think it's appropriate anymore, whether it's of ongoing viability, or whether the birth of it coming out of the civil rights struggle is a means to combat what the southern states were doing by using the tort as a means to chill expression. Was that right? Was it too expansive? Was it wrong? Was it right for the time but not right anymore? These questions are on the table in our ever-changing world with our ever-changing Supreme Court that we've recently seen. So stay tuned for an update on the Deppamation case study as we fast forward and see what happens with New York Times v. Sullivan in the coming years. But for now, let's pivot before we get back to our Depp-Heard trial to the anti-SLAPP statutes that exist. And these anti-SLAPP statutes directly end up touching defamation cases in particular because of the very nature of the statutes. And so these are statutes that are aimed at halting strategic lawsuits against public participation, and it's often then defamation claims. And basically these anti-SLAPP laws, as they're known, are intended to prevent people from using courts and the potential threats of a lawsuit to intimidate people who are exercising their First Amendment rights. And so California's Code of Civil Procedure has its anti-SLAPP statute at section 425.16, and this is basically the legislative statement, which is, the legislature finds and declares that there has been a disturbing increase in lawsuits brought primarily to chill the valid exercise of constitutional rights of freedom of speech and the petition for the redress of grievances. The legislature finds and declares that it is in the public interest to encourage continued participation in matters of public significance, and that this participation should not be chilled through abuse of the judicial process. To this end, this section shall be construed broadly. And so procedurally, this is how it works. If a lawsuit arguably interferes with public participation, like you're sued for defamation on something you said, you as a defendant can file a special motion to strike out of the gate. And on the next slide, you see how this special motion to strike works. It's sort of an early push on the merits of a case, of a defamation plaintiff's case. So a cause of action against a person arising from any act of that person in furtherance of the person's right to petition or free speech under the U.S. Constitution or the California Constitution in connection with the public issues shall be subject to a special motion to strike unless the court determines the plaintiff's established as a probability the plaintiff will prevail on the merits. And so the court looks at the pleadings and declarations and evidence to figure out if there's a probability that the plaintiff will prevail. And so if the court determines that the plaintiff does show a probability of prevailing on the merits, that's not admissible later on, but that allows the case to go forward. But if the court doesn't, then the case can be early dismissed out of court. And so basically the way it works, as you see on the next slide here, as a structural matter, is that the defendant files this motion and makes a prima facie showing that the plaintiff's suit arises from an act in furtherance of the defendant's petitioning or free speech activities. And then the courts ask these two questions. What conduct does a claim arise from? And is that conduct in furtherance of the rights of petitioning or free speech? And that can be very, very broad. And if the defendant makes the required showing, the plaintiff then must demonstrate a probability of success on the merits. And so let's just take a look here as one example case. This is Wilson versus CNN. It went to the California Supreme Court, 7 Cal 5th 871. And this looks at the real scope of the anti-SLAPP statute in terms of knocking cases out early, plaintiff's cases. So here, plaintiff sues CNN saying I was denied promotions, I got unfavorable assignments, and then I was fired ultimately for retaliatory reasons against me. CNN went to court and said, hold on, you were fired in part for plagiarism. And therefore, because we fired you for plagiarism and we're a public news broadcasting type company or private news broadcasting company, you got to make a prima facie showing of merit to your suit. And so what the Supreme Court held is that whether the defendant's acts qualify in furtherance of speech or petitioning does depend on whether the defendant took the action for speech-related reasons. And here, CNN argued that its selection of content producers was necessarily part of its speech-related activities. It decided who would be a content creating, producing employee to then give public content to the public, and that its decision to enforce its journalistic standards by terminating someone for alleged plagiarism was indeed protective speech-type activity, and it couldn't just be sued for it absent this plaintiff having to make a special showing out of the gate. And the court agreed. The California Supreme Court held that's correct, and so the plaintiff, as a result, was required at the pleading stage to then actually come forward with some factual evidence to show that there was some level of merit to the termination claim in order to justify the case going forward. And absent that advanced factual showing, pre-discovery, no right to discovery, just you have to have real facts and put some meat on the bone out of the gate. Absent that, the case gets dismissed. So this brings us to a postscript before we talk about our conclusions. As you may know, after the jury in the Johnny Depp Amber Heard trial issued its verdict, we then saw multiple press accounts of Amber Heard giving yet more press interviews restating the same claims that she had already lost on trial on in terms of how Johnny Depp had physically abused her at various points over time. And she then restated those claims in some interviews, and she's apparently going to author a tell-all book where she will again publish yet again those statements. And so the postscript to this is, will there be a Depp-Heard Part 2 trial? If it's Hollywood, there has to be a sequel, so stay tuned. There may be a Deppamation Part 2 program down the road, because if we follow suit like Hollywood, one can imagine more defamation lawsuits coming. So the ultimate question that we as lawyers ask in this Deppamation program on defamation is it worth it? And that's a question that we as lawyers can't necessarily answer, because these are issues that clients have to drive in terms of how they understand the nature of the action benefiting them or harming them within their given industry. And so it's in the eye of the beholder as to whether Johnny Depp's verdict against Amber Heard with her counter verdict against him and the airing of all that, did that really help him? Did it really hurt him? It's in the eye of the beholder, and that's something that he and his people and our clients and the industry they work in would need to assess, categorize, monetize, and understand. But us as lawyers, we need to be very, very clear that this is a minefield. And so long as you are very clear in your written exchanges with your clients that you're advising them on the expansive nature of what may happen, that yes, they may win a trial, but there may be massive amounts of publicity about, drug use and threatening to have sex with dead corpses and all that stuff. And all of that stuff, even if you win the case, that stuff may damage you in the court of public opinion in a bigger way. So long as you lay it out for them and they go in eyes wide open, not eyes wide shut or one eye shut like a one-eyed pirate, then we've done our job. And so reminding clients, of course, the incredibly broad nature of relevancy and on the damages side, and not forgetting the difficulty then of proving damages so that you're prepared to prove it, is very, very important. Recognizing online immunity in the online immunity era is very, very important to be cautious about suing online service providers lest you find yourself experiencing an anti-SLAPP motion and losing on 230 immunity. And again, remember the damages issues in causation correlation are very, very important. Finally, U.S. Supreme Court, there really are large pending issues about the constitutional bedrock basis for the New York Times versus Sullivan rule, and whether really this is going to be a continuing part of our First Amendment jurisprudence as it injects itself into state defamation torts. So stay tuned, and stay tuned for the sequel. Thank you.